Welcome to Rebel Chaser. My name is Gail, and I have two videos to show you to update you on this case. The judge is Judge Marilyn Hahn from the Cowlitz County Superior Court in Washington. And I think you guys remember this case because I get asked about it a lot. But this is parts 6 and 7 for this. And part 6 is the first one you're going to see. Grandma filed to have the case moved to Oregon. So they are having what's called a UCCJEA hearing, and that stands for Uniform Child Custody Jurisdiction and Enforcement Act. And it's to see who has jurisdiction. So that's the first one. And then the second video was today. And in that video, the mother motioned to disqualify the guardians, basically trying to throw shade on them. So I'll let you guys watch.
All right, we do have, let's see, Mr. Flay, who is the attorney for the current guardians, as well as Mr. Goodday, who is the attorney for the mother, and Amy Turnbull, who is our I believe she's on as the guardian ad litem, and the father consented back in October of 23. So with that, how would any particular order you'd like to proceed in?
Well, and I guess for purposes of your record, this is Judge Peterson in Clatsop County, Oregon, and I'm happy to hear your thoughts on it. But when I reviewed the petition that was filed in my case by, I think it's Celeste Mitchell, if I remember right, is the child's mother's mother, so maternal grandmother, I didn't see any real allegations that would give Oregon home state jurisdiction. But I was curious if you saw anything that I missed.
I did not. And what I see is that Washington has been the home state at the time that this was started, that we had a hearing. I can't recall what date that was, but mother indicated at that hearing that she was in Tacoma, Washington. So it still appears to be Washington. And so the information that I have regarding the child all seem to be indicated in the state of Washington, in particular Cowlitz County, at least in part in Cowlitz County, or primarily, I should say.
Yeah, and I did review a portion of your records. I think your judicial assistant emailed me the moving papers essentially and some of the declarations. And yeah, I agree completely. I think you've got home state, and I don't see any basis for Oregon to try and step in on it.
Okay. Under Washington, we do have to give Mr. Flay and Mr. Goodday an opportunity to be heard.
Sure.
Mr. Flay, anything you wanted to add?
It sounds like everything was reviewed pretty thoroughly by Judge Peterson. I can't say that there's really much more to add. Our declaration that we filed on February 9th, I'm assuming that was reviewed as well, but it covers everything that we historically have done the case. So I don't think there's much further to discuss.
Mr. Goodday, anything you'd like to say?
No, Your Honor. Thank you, though.
Okay. All right. So with that, and just on a total aside, Judge Peterson, this isn't related to this, but Mr. Goodday, you seem to have a motion on today, and that just needs to be noted up for a regular calendar.
Yeah, Your Honor. I filed that, and I just wanted to see if we can get a hearing date set today.
Okay. I won't be doing that on a UCCJEA hearing.
Understood. I will get that noted up properly.
All right. Thank you. All right. So with that, it sounds like we have an agreement that Washington, in particular Cowlitz County is the home state of the minor, and the matter will remain in Washington.
Yep. Yeah, that would be my understanding and my agreement. And thank you for being available and taking care of this.
All right, thank you. Take care.
Thank you, Your Honor.
And that is the guardianship of Emma Ryan.
This is Amy Turnbull, the guardian ad litem on this case.
Morning, Your Honor. Rory Flay on your petitioners.
Okay. Mr. Gooday, are you there?
Yes, Your Honor, good morning.
Good morning. Okay, do we have anyone else appearing on that matter?
Matt Brooke English as well.
Good morning, Your Honor.
Good morning. Okay, excuse me. Let's first take up the motion filed by Mr. Gooday on behalf of his client.
Yes, Your Honor, did you have a chance to look through that?
I did. Go ahead.
So my client brought up to me the fact that she knows that the petitioners have criminal history. She showed that to me, so I went ahead and printed that out for Your Honor. CR 60 says that relief from judgment can be obtained if there's a misrepresentation of facts or new information ascertained. Petitioners submitted watch reports, which show that they have no criminal history, which I think is a misrepresentation because there's a lot of criminal history in Oregon. And I cited another statute that says the court should look at the judicial information system when making rulings. And I think in this case, rather hastily, just there's a lot of different judges, and I know Judge Warning was on it and Judge Scudder was on it, and my client was ordered to turn her child over to the petitioners, but she doesn't feel comfortable. And I think she mentioned that Mr. English had been to prison before. I don't know if that's true or not. I don't know what the histories are, because the watch report showed no history, so I was only able to find, just what I was able to search on the Oregon Odyssey system. So I'd ask Your Honor to relieve my client from the order requiring her to turn Emma over to the petitioners. And I'd ask Your Honor to set a new hearing where a decision could be made once Your Honor is able to ascertain the full extent of the criminal histories of the petitioners. Thank you.
Just for everyone's, I looked at JIS. There's nothing shown on JIS. So, if that's what you were talking about, there's nothing showing. So, Mr. Flay.
Thank you, Your Honor. I will keep this brief, and as I noted to the court, I do have another matter on Clickitat docket I've been waiting on, so I definitely want to keep this brief. This is just another attempt by Ms. Ryan to obfuscate the ruling of the court. She clearly does not want to give up Emma to my clients. We've gone over the criminal history. She's been aware of the criminal history, as noted in her testimony in other cases. If this was such an issue, why did she wait until February 2024 when this case was ordered in September 2023? It's again another motion in her attempt to bypass what the court has ruled. She has a warrant out for her arrest. She was in Clatsop County by my clients, had the opportunity to give Emma to my clients per the court order, and this is just another waste of my client's time, energy, and money to get this done. It's absolutely absurd that we've come this far. I don't think Mr. Goodday has met the burden to qualify for this motion for relief, and moreover, the court has the discretion to uphold this guardianship as the petitioners are family members. So having criminal background, even if it was 20 plus years ago, does still not bar them from being minor guardianship petitioners in this case. So we would ask, Your Honor, that this be, at least for now, set aside until Ms. Ryan gives up Emma Ryan to my clients, and we can have this ruling at a later date if it's absolutely necessary. But ultimately, we'd be asking this just be stricken and not heard again. Per the court's previous ruling about Ms. Ryan filing motions for dismiss based on venue, we'd also ask for she be barred from filing motions to dismiss for anything related to background checks or anything like that in the future. That will be all from us, Your Honor. Thank you.
All right, do I have any input from the guardian ad litem?
Not in regard to the criminal background. I don't have concerns in regard to the English's background at this time.
All right. All right, Mr. Gooday, anything further?
No, Your Honor, I just asked, well, I would ask that you figure out what the exact criminal history is because we don't know it.
All right.
And Your Honor, to clarify, I think everything's been filed that's of the record on the English's criminal history.
So in regard to the criminal history, as I indicated, I did check the judicial information system. Nothing shows for the petitioners. And based on the files and record, the court accepts what has been filed. The mother had prior knowledge of the criminal history as stated in the motion. The age of the criminal history is 15 to 25 years old, noting most of the cases were dismissed. And RCW 11.130.090 print 1 print B print double I does not prohibit the petitioners to serve as a guardian or conservator. The guardian ad litem does not have any concerns in regard to the history. And that's just it. It's history. It's significantly old history. And based on this, the court does not have concern and denies the motion of the mother. Whether something is filed again, I'll leave that to counsel. Whether the court will consider it again or something new, that will depend on what it is at that time. But at this point, the motion is denied. And so with that, Ms. Turnbull, you had something more?
I did. I have had the opportunity to speak with Emma over Zoom, and she would like to have an attorney appointed to her. I wanted to bring that to your attention.
How old is Emma?
She is 13.
Okay. All right. All right, that will be done. Do I have, is there, well, Ms. Turnbull, I may have my assistant Autumn Terry contact you because she's going to have to get the information to Emma
Okay.
in regard to who that would be after she locates somebody. Okay.
Okay, that's fine.
All right. All right. So with that, we still have the warrant out. The mother is still in violation of the court order. So with that, and we'll get the attorney on board. Where are we as far as the report? Are you thinking 30 days or what are you thinking?
Yes, 30 days should be sufficient.
Okay. All right. So I'm going to set two dates here. One is, well, I'll go ahead and just get it in the works to get an attorney for Emma. And then if that attorney needs to set something on, that can happen. But meanwhile, I'll just set this matter over to April 4. Does that work for everybody? And see where
apologize. I'll be on vacation that week. Could we do the week after?
the 11th? Does that work
Yes,
for
please.
everyone?
That's fine for us, Your Honor.
Mr. Goody?
No objection.
Okay. Mr. Play?
I just wanted to request, Your Honor, that Ms. Ryan is on the Zoom call. I don't know if she's willing to provide us any information where Emma is. And again, we are requesting that she give up Emma to the Englishes. She's apparently here, so I believe she should be able to attest to that. But that would be all we would ask any further, Your Honor.
Okay. So do we have Lauren Ryan online?
Your Honor, it appears that she is no longer connected after that request.
Okay. All right, well, the warrant's still out, still active, and unfortunately, I'm not sure what else to do at this point. Someone in direct violation, and she'll pay the consequences when unfortunately once located.
Oh, sorry, Your Honor.
Go ahead.
I was going to ask, could we request another $3,000 in attorney's fees for response to Ms. Ryan's motion today?
So in regard to the motion, I don't think it's necessarily inappropriate. You know, she did know about it. Why it was brought so late is beyond, is not, I don't know why. But with that, I won't order the whole 3,000, but I will order 2,000 as appropriate, given the length of time this has been pending. The mother knew about it, and the court does see that it was important information at the same time, very, very old history, but it could
Your Honor,
have
can
been long ago. Go ahead, Mr. Gooday, I apologize.
No problem. I guess she just didn't realize that that was an option, because we did bring about it at the other hearing, and she spoke to another attorney, and they said that we should file that motion based on new evidence. So it wasn't like we realized what we could do. Is just, as things developed, you know, learning more as the case goes on. And also, I would point out that I don't think Mr. Flay responded. It was just a declaration by Miss English. So I'd ask Your Honor, minimal attorney fees.
He did respond. That's why I knew what the history was, or is. So with that, again, mom is, from what I can see, delay tactics for not following and complying with the order that she is required to follow. And that she had this information, and now saying it's new information is not correct. That somehow it's misleading. From what I see, everything was complied with, that's required by statute. And so for that reason, I'm still ordering the $2,000 in attorney's fees, and I would order that be paid within 90 days. And then I'm assuming, Mr. Flay, you want an extension of the order?
Yes, Your Honor.
Okay, I'll fill out an extension as well.
Thank you, Your Honor.
So again, setting this over to March, what did I say, 14th at 10:30.
Thank you, Your Honor.
Thank you. That concludes this docket.
Thank you.
Oh, April 11. Oh, I apologize. April 11. That's where the 11 came from. April 11. All right. Thank you.
Thank you.
Thank you, Your Honor.
It's pretty telling when someone tries to speak with her and she immediately hangs up. And her attorney is supposed to be telling her to immediately turn herself in. He could be held in contempt if he does not do that, because she's got a warrant out for her arrest. That is what he's supposed to be telling her at this point in time. And allegedly, this is her MO. She had another child taken away from her because apparently, allegedly, she has a pretty violent history towards her children. And that's why her kids get taken away from her. And the last time this happened, she did the exact same thing as she's doing now. She hid the child. Her and grandma both hid the child, allegedly. And she was held in contempt and had warrants out for her arrest back then. Now, I don't know why grandma doesn't. Grandma should also, because she's facilitating. She's aiding and abetting. So anyway, that's my opinion. Let me know what you guys think. Thank you so much for watching. And I will post 1 through 4. I will post them. I'll pin them in the comments. So it'll be the top comment. You'll be able to see 1, 2, 3, 4, all the other videos I've done on this case. So thank you guys for watching, and I'll see you next time.